You are live. You are muted. You can go to the class. So go ahead.
Reading to all of you. We have finished up to 61, section 61. Yes, section 61 deals with, again repeating it, that where there are two mortgages and the mortgagor is entitled to redeem both of them or one separately and another joint. So you can redeem it or you can pay back the money in respect of both the mortgages and then get back the property. That's what section 61 says. Then section 62 deals with rights of usufructuary mortgagor to recover possession, payment within the term, and then it is said in a usufructuary mortgage, a mortgagor cannot file a suit for redemption. What all he can ask is he can ask for redelivery of possession once he pays back the money or the rents collected, the profits collected, annuities collected, or the profits arising out of the business collected are sufficient to discharge the loan, he is entitled to get back possession of the property. He can file a suit for redelivery of possession under the provisions of section 62. Then 63 deals with accession. If the mortgage pays the money for accession, the mortgagor has to pay the money. Here, accession means, especially if the property is near the seashore or is near a river, there are two things called alluvion and diluvian. Alluvion is some extra part of the lake waters come into the land, and that is what is called accession. The extra area that is added to the property that is offered as security, the mortgagor and paying the money in respect of that added property is entitled to get back the property. That's what section 63 deals with. Then we go to section 64. All these sections are academic sections. That's the reason why I'm going at a faster pace. Then mortgage lease. Suppose we are in Hyderabad, some of the properties here in Hyderabad are leasehold properties. That is the paramount rights of the government is recognized, and you are only the owner of the superstructure, and the land or the soil belongs to the government, and you are only a lessee. Suppose the leasehold is offered as security, then please remember it is given for a fixed duration of time, 20 years or 25 years or 30 years. It is normally executed by the estates officer, if it is a municipal area, by estates officer GHMC in your favor. And suppose the lease is for 30 years and you get the lease extended, then the renewal of lease endures to the benefit of the mortgagee. Here, then implied contracts by mortgagor, 65. Interest subsists. That is, when the mortgage is created, security is given. He should say that I have got a present interest over the property. I have got the titular rights over the property. I have got possessory rights over the property. And that interest which I have survives or subsists on the date when I offered the property as security. That is one of the implications, sir. Second one is mortgagor will defend all litigations or vice versa. Here, suppose any litigation arises in respect of the property, the mortgagor will have to defend the same because the interest of the mortgage is involved, because the property which is in dispute is part of the security which has been offered to the mortgagee for the purpose of securing the loan. Then the mortgagor to pay public charges. As far as the municipal charges are concerned, land revenue is concerned, or any cess that is concerned, it is the duty of the mortgagor to pay the money periodically. And fourth one is that where it is a lease, that the rents payable under the lease contain and the contracts binding on the decree has been paid, and if the mortgagee is in possession, rents have to be paid and all conditions performed even on renewal. Even if the leasehold is renewed, the question is the lessee becomes liable to pay the lease rent to the government, or the non-agricultural tax to the government, or the cess to the government, or the land revenue to the government. All these things he has to pay and produce the receipts to the mortgagee. And whenever renewal takes place, it endures to the benefit of the mortgage. Mortgagee holds the security. And next one is Mortgagor shall discharge all payments where it is second or subsequent encumbrance. Suppose second and third encumbrance are there. The question is in addition to discharging the first mortgage, he has to also discharge the second and the third mortgage in respect of the same property. Then 67 is mortgagee when bound to bring suit on secured mortgage. Here he has to sue on all the mortgage. Please remember, I just take you to the law of civil procedure, order 2, rule 2, splitting of claims, joinder of causes of action. Suppose the mortgagor is the same, mortgage is the same, and the debts are given on two occasions. Two mortgages are there. He must bring a single suit clubbing up both the mortgages, and he cannot file separate suits in respect of each mortgage. Joinder of causes of action is the same. If the creditor is the same and the debtor is the same, but two different properties are given, then in that case, in respect of both the properties, a common suit has to be brought. It cannot be split up. Then 68 deals with right to sue for mortgage money. When the mortgage binds himself to repay where except wrongful act on the part of the mortgagor or mortgagee, the property is partially destroyed or the security insufficient, where the mortgagee is deprived of the security due to wrongful act to the mortgagor, where the mortgagee is entitled to possession, the mortgagee fails to deliver possession. So in all these cases, the question is the right to sue. That is the default or the violation committed by the mortgagor as far as the terms of the mortgage is concerned. When he does not pay, when he binds himself to repay, personally he does not pay. Second one is when he does a wrongful act, where due to the wrongful act of the mortgagor or the mortgagee, the property is destroyed or the security is insufficient. Then next one is where mortgage is deprived of security due to wrongful act of the mortgagor, where the mortgagor is entitled to possession, mortgagor fails to deliver possession. Suppose the mortgagee has to get possession. Mortgagor does not deliver possession. Second one is due to the wrongful act of the mortgagor. The mortgagee is deprived of the entire security. It is destroyed partially or completely. Then in the cases, suppose the security that is available after destruction is insufficient to meet the contractual obligations as far as the payment of the debt is concerned, the mortgagee can immediately recall the debt and file the suit for enforcement of mortgage under the provisions of Order 34 Civil Procedure Code. Then transferee from the mortgage, of course, the question is suppose in the meanwhile the mortgagor alienates the property or mortgage exhausts all, that is, here if the property is already sold by the mortgagor during the pendency of the mortgage, then the case is suppose the transferee acts in good faith, bona fide, and for consideration without notice of the mortgage, then his title is protected. Then mortgage exhausts all remedies, that is, before filing a suit for mortgage, the mortgagee will have to exhaust all his remedies by giving a notice, asking the mortgagor to pay, then make a demand, so on and so forth. Then next section is section 69, power of sale when more valid. Mortgage is a right to sell in default where it is English mortgage, power to sell without intervention of the court, confirmed by the deed, notice in writing, 500 rupees interest is due, where the sale has been made in exercise of the power, the title of the transferee cannot be challenged. Here, as far as English mortgage is concerned, the property is ostensibly sold, the title is transferred by the mortgagor to the mortgagee on the condition that the debt will be paid within a particular date. And in case of the debt not being paid within a particular date, the sale shall become void. And in case the debt is paid, the property will be retransferred. That is the essence of an English mortgage. But here, the mortgagee can always bring a suit to sell the property which has been offered as security in the case of English mortgage. And even without the intervention of the court, he can, and if it is incorporated in the deed that he can sell even without going to the court, then he can exhaust that remedy and then recover his money. Then, but one condition is the interest should not be more than 500 rupees. That is, in 500 rupees interest is due. Notice has to be given in writing and in exercise the title of the transferee. But in case the transferee purchases the property without notice, his title is protected. That the money which is received by the mortgage after discharge of prior encumbrance to the sale, not made subject to payment into government, the money held by him in trust has to be applied for. So these things you can avoid. Then 69A deals with receiver. Suppose the property is wasted, property is not managed properly, then in that case, the mortgagee can ask the court to appoint a receiver to manage the property, collect the income out of the property, collect the rents out of the property, collect the profits as far as the business is concerned, then deposit it to the credit of the court. And suppose, let us say, it's a 70 deals with accession to mortgage property. What do you mean by accession? Whenever there's an alluvion, sometimes what happens is some of the land belonging to the river belt comes into the land which is offered as security. That is what is called alluvion. Sometimes what happens is the land sometimes gets submerged in water. That is called diluvium. But suppose there's an alluvion, there is an accession, there's an added area which has come into the property, then that also is available for what is called as a security against which the mortgagee can proceed. Then rights of mortgage in possession. As far as mortgage in possession is concerned, he must do all things possible, repair the property whenever required. He must also collect the rents, and he must preserve the property, and he must support the title of the mortgagor at all costs. And whenever lease is there, suppose the mortgagor is not able to pay, the mortgagee will have to pay and take the benefit of the security. That is what Section 72 deals with. Then 73 is right to proceeds of revenue sale or compensation on acquisition. Suppose, let us say, can claim mortgage money, acquisition entitled to compensation. Suppose the property is acquired by the government for arrears of land revenue. That is what is called Dasta Gardhan. In Urdu, it is called Dasta Gardan. In revenue language, it's called Dasta Gardan. That means when the arrears of land revenue is not paid, the government has got the property right to attach the property, sell the property, then recover the money. Sometimes what happens is, suppose it's acquired under the land acquisition purpose, then in that case, the compensation becomes payable to the mortgagee, and whatever excess amount is there apart from the debt, that will have to be paid to the mortgagor. Then right to section 73 deals with rights to proceeds of revenue sale or compensation. Then then 70 73 here 75 deals with liabilities of mortgagees in possession. Suppose the mortgage is in possession of the property, he has to manage it properly, pay the government revenue from out of the income, then collect the rents, and then no acts of destruction, insurance, proper accounts, then occupation rents and receipts, proper accounting. Here, what the mortgage, suppose the mortgage is in possession, he has to pay the land revenue, he has to get the lease renewed, then he has to properly manage the property, he has to collect the income arising out of the property, maintain proper accounts, and prevent the property from destruction, and if possible, get the property also insured as per law. And then he has to maintain proper accounts. And suppose he is himself in occupation, whatever is the probable rent, he must deduct it from the amounts due and payable by the mortgagor and maintain proper accounts. And here, this is what section 76 deals with. Then, whatever amounts are received, 77 says, whatever amounts are received by way of rents, by way of profits, by way of share of crop, by way of annuities, or profits arising out of the business, that is normally added on to the interest which is liable to be paid by the mortgagor to the mortgagee. That is what section 77 deals with. Then 78 deals with what is called postponement of prior mortgage due to fraud. Here, there is a maxim, sir. Key prior, QUI, prior, PRIOR, SEST, S, tempore, TEMPORE, D, jure, D, DE, jure, JURE. Normally, the maxim is according to the doctrine of priorities. One who is in prior in time normally prevails. But sometimes, let us say, the same mortgagor goes to a second mortgagee or a third mortgagee, mortgages the same property to them, and the first mortgagee does not alert them, does not take the earlier available action by cautioning the second and the third mortgagee that he is the first mortgagee, he is the first bakra rather. Then in that case, what happens is a fraud is played by the first mortgagee in collusion with the mortgagor. Then in that case, the claim of the first mortgagee is postponed till such time the second and the third mortgage is satisfied. That is what is section 78. 79 is mortgagees to secure uncertain amount when maximum express. Subsequent mortgage postponed by notice. Suppose let us say subsequent, that is mortgages to secure uncertain amount when maximum express. I told you this arises mostly in the case of banks where limits are normally prescribed. Suppose you apply for a loan of 1 crore and the bank in the sanction letter sanctions only 50 lakhs. Then, till that maximum is reached, the question is the security will, when the maximum is expressed, till such time the maximum is arrived, the mortgage survives or subsists. Then we go to the most important maxim called marshalling of securities and contribution. Marshalling in section 80 means where there is a mortgagee number one, mortgagee number two, let us say A mortgages the property X to Y. A mortgages the property X to P, let us say. Then A again mortgages, creates a second mortgage, mortgages property Y to Q. Then there's a third mortgage. What A does is he creates another mortgage in respect of property Y and receives the loan from B. Here B holds two mortgages, C holds one mortgage. B holds mortgages in respect of what? Property X and property Y. As far as C is concerned, he holds property Y only as a security. Then the subsequent mortgagee, that is Y, that is C, can ask the prior mortgagee, Mr. B, please satisfy your debt from out of sale of the property X. Leave property Y to me. If anything is insufficient, proceed against property Y. Then in this case, what happens is there is a mutual adjustment of debts between B and C. That is, C can direct the prior mortgagee, sir, look, you just don't proceed against the property that is mortgaged to me. Proceed against the property which is mortgaged to you. If anything is insufficient, then proceed against this property Y. Then what is the advantage the second mortgagee gets? Second mortgagee gets the composite security property Y against which he can proceed and then recover his money. This is what is called marshalling of securities. And this is a right which is available to a puny or a subsequent mortgagee against the prior mortgagee. Then next one is contribution. Two or more persons having distinct and separate rights contribute ratably where it belongs to the same person and the debt is paid out of the first property. Each property is liable to contribute ratably after deducting the amount of the former debt from the value of the property out of which it is paid. Suppose, let us say, a single person, or let us say two or more persons own properties in distinct shares and they have got separate rights. In the absence of any contract to the contract, a contract to the contra, each property is liable to contribute ratably according to the investment made by the two persons. But where it belongs to one person, then suppose the debt is paid from out of the sale of the first property and the second property remains, if any surplus is there, it is added on to the second mortgage and the amount already paid will be deducted and ratably it will be collected. That is what is called contribution. Then 83 gives a power to the mortgagor to deposit the money into the court. Whatever money is due towards the principal, towards the interest, and towards the cost. If he deposits the money into court after notice to the mortgagee, under section 84, the interest ceases from the date of deposit. Then other sections are there, sir, 85, 86, 87, 88, 89, and 90. They have been repealed. They are no more available. Then section 91, persons who may sue. Here, I take you to the doctrine of privity of contract. Here, as far as redemption is concerned, the mortgagor, the subsequent mortgagees, or the LRs of the mortgagor, or the assignees of the mortgagor, or the transferees in interest of the mortgagor, or any other person can sue on behalf of the mortgagor. So the right of redemption is not, the doctrine of privity of contract does not apply as far as redemption is concerned. Any person can bring a suit provided he has been duly authorized. That is the mortgagor, surety, and the creditor. The subsequent creditor also can redeem the mortgage by paying back the debts to the prior mortgage. That is why it is said, as far as the section 91 is concerned, it goes from down to top, ascending order. If B, C, and D are there, if D wants to get a promotion, D has to pay C and B, and then come to the position of B. If C wants to redeem it, he must pay B and then foreclose as far as the mortgagor is concerned and D is concerned. So normally it is said a mortgagor can himself redeem the property by paying back the money, or a surety whose liability is coextensive with that of the debtor, he can also pay back the amount. Or next one is a creditor, a puny creditor who is below the prior creditor. He can also redeem the mortgage by paying back the money to the mortgagee. This is what section 91 deals with. Then we go to a very important doctrine called doctrine of subrogation. Here, what do you mean by subrogation? Subrogation means, excuse me, subrogation means substitution, where let us say the some other person, or let us say a creditor or a surety pays the money due and payable by the mortgagor to the mortgagee, then all the securities which are had and received by the mortgagee has to be transferred to the person who has paid the debt. Or in other words, the person who pays the debt steps into the shoes of the creditor, and then he can sue the mortgagor as if he is the creditor himself. So the doctrine of privity of contract does not apply. One classic example I can tell you, sir. Nowadays, what is happening is, in contract of what is called carriage, contract of carriage, it is called a CIF contract, cost, insurance, and freight. The cost of the goods is mentioned, insurance premium that is paid is mentioned, and the freight also, which is liable to be charged, is also mentioned. Suppose the goods are handed over to the carrier for the purpose of being transported from Vizag to Hyderabad. Then the carrier is a mercantile agent whose business is to carry goods from one place to another place. Then let us say the goods are insured. When the insurance takes place, what happens is the insurer, the carrier, as well as the consignee, the person who is to deliver the goods, all the three enter into the contract. It's a triumvirate insurance policy that is issued. So what is a marine insurance, sir? A marine insurance means, as far as the liability of the insurance company is concerned, if the goods are lost in transit, if the goods are destroyed during transit, if the goods are damaged during transit, or if the goods are destroyed beyond redemption, then in that case, the insurance company, after ascertainment or appraisal of the loss cost, pays the consignee the value of the goods which are transported. But in other words, suppose let us say there is dereliction of duty on the part of the carrier, he is negligent. When an accident takes place, he does not report to the police station, he does not initiate an FIR, he does not get a Panchanama recorded by the police. Then in that case, the insurance company, along with the consignor, join together and file a suit against the carrier. Whatever money is paid by the insurance company to the consignee for loss or destruction of the goods or damage to the goods, that will be recovered from the carrier. In one of my cases where I appeared for one of the, I think if I'm correct, Jagjit Carriers Private Limited that belonged to Ludhiana. The goods were to be carried from Punjab to Hyderabad. But due to the bad roads, what I think the goods which were carried was what is called chemicals. It contained about 20 drums of chemicals which are used for commercial purposes. Then on the way, what happened was there was uh, there was a destruction of the goods due to reasons beyond the control of the carrier, and out of that, 4 drums got damaged. And those chemicals are very much essential and necessary for the consignee. Then what happened was the first appraisal took place in the presence of the carrier and in the presence of the consignor, and the insurance company held that there was only 4 drums which were damaged and 16 drums were intact. But what happened was the insurance company colluded with the consignee or the consignor and gave a report saying that all the 20 drums are damaged, and the question of payment of compensation had been necessitated, and the insurance company paid the compensation. And since the compensation was paid because of the negligence on the part of the carrier in carrying the goods, the accident has occurred, and so the carrier is to be responsible. Then it so happens, sir, and normally when the appraisal is done, when the damage is to be recorded, both the consignor and the consignee and the carrier has to be present. But the insurance company, the field officer of the insurance company colluded with the parties and then held that all the 20 drums were damaged. But ultimately, in evidence, it turned out that only 4 drums were damaged and 16 drums were taken delivery of by the consignee, and they were sold in the market. And the carrier, I think they, it belonged to a Punjabi company, a Sardarji. They were very, very careful. They launched an FIR, they got a Panchanama done, and in the Panchanama also they said, the Panchanama report said that only 4 drums are damaged and 16 drums are intact. Ultimately, what happened was the claim was made for a very big amount. I think 3 lakhs or 3.5 lakhs. The claim was made. The value of the 20 drums. But what the court in this case did was it deducted, it awarded damages only to the extent of 4 drums, and regarding 16 drums, it rejected it. Of course, my client, that is the carrier, was very, very, very keen to prefer an appeal. I told him there is no point in filing an appeal. Sir, why do you want to file? I said, why are you bothered? You take your fees and file the appeal. We filed the appeal. In the meanwhile, the insurance company came for a compromise, and they received about 2 lakhs lesser than the amount what they claimed. And ultimately, the matter was settled. What I'm trying to tell you is whenever an accident takes place, whenever a destruction takes place, whenever a damage takes place, whenever a deterioration takes place, it is a duty of the carrier to report it to the police station immediately, lodge an FIR, and also get a Panchanama done. And then he gets discharged from his duties to say there is no negligence or there is no dereliction of duty on his part. In this case, the carrier did everything, and ultimately only 4 drums were damaged, 16 drums were intact. So the court, what it did was it awarded damages only to the extent of 4 drums, and as far as 16 drums are concerned, they rejected it. Ultimately, the insurance company itself came for a compromise, and they received much less than the amount actually which is due and payable to them, because there is a fraud committed by the insurance company. Then we go to section 93. 93 deals with what is called tacking, TACKING. Mortgagee, that is, mortgagee paying the prior mortgagee with or without notice acquires priority. Suppose, let us say, the subsequent mortgagee pays back the prior mortgagee for and on behalf of the mortgagor, redeems the property, then not only the amount what he has paid to redeem the first mortgage, but the amount which he has to get towards the second mortgage, both of them get tagged to each other, and he can file a consolidated suit regarding the money which he has paid to discharge the first obligation, and the money which is due and payable to him as far as the second mortgage is concerned. This in law is called tacking. Then next one, sir. Rights of puny mortgagee, that is, has the same rights as puny mortgagee or subsequent mortgagees are concerned. If they want to get priority, they must pay the prior mortgagee, and then they can step into the shoes of the prior mortgagee and then recover the debt not only as far as he is concerned, but whatever money he has paid for and on behalf of the mortgagor to redeem the first mortgage. Then the 95 and 96 you can just avoid, sir. 96 is deposit of title deeds. As far as deposit of title deeds is concerned, it is said where by word of mouth conduct or by implication the mortgagor deposits the original documents of title pertaining to his property with the mortgagee to secure a debt which is paid, promise, part paid or part promise. It is called a mortgage by deposit of title deeds. A charge is created over the property whose documents are deposited with the creditor. Then, in that case, the same rights apply what applies in the previous sections. Then, anomalous mortgage. Anomalous mortgage, please remember, it is a combination or it's an agglomerate of two or more mortgages contained in a single document, and the enforcement of the mortgage or otherwise depends upon the intention of the parties or the contract which they have arrived between themselves. And the question is, suppose it's a combination of simple and English mortgage. You can ask for the money, payment of money, and you can also enforce the charge as far as the property that is offered as security. Or you can also get the property sold if it's in the case of an English mortgage. So normally anomalous mortgage is very, very rare. It doesn't come into play everywhere. Then we go to the most important section called charges. Charges means here it is said operation of law and undertaking not to alienate duly stamped and right to merger in case of subsequent mortgage. Here, what do you mean by charge? Charge means where the property of one person becomes liable to pay the debt of another person, and a prohibition is introduced as far as that property is concerned, that is earmarked for the benefit of a person to whom the amount is due and payable. It is called a charge. Charge can be created either by law, either by act of parties, or by operation of law. I'll give you a concrete example, sir. Suppose, let us say, the father transfers all his property to his eldest son, but one of the property he keeps it apart and tells the eldest son, "Sir, this is meant for marriage of your sister, and this is for the marriage portion to perform the, because I may live or I may not live." The question is, the daughter has to be married from out of the share of that property. And yeah, and it's also said that that property or that particular portion which is kept apart, it cannot be sold under any circumstances. That means there is an embargo as far as selling that portion which is kept apart for the benefit of an unmarried daughter or a widowed daughter who is dependent upon the family for our maintenance and sustenance, or to keep her body and soul together, and that is called a charge. And charge can also arise, sir. Mostly, in criminal case, some of you are doing criminal cases know that under section 4, I think I'm talking about the old act, 435, 436, and 437 of the old CRPC. When you ask for bail in a cognizable case, a non-bailable case, let us say, then in that case the court orders personal bond as well as surety to be furnished. That is surety to the extent of 10,000 or 20,000 or 1 lakh. We see the latest judgment of the Supreme Court in Sisodia's case. When bail was granted, he was asked to furnish security to the extent of 10 lakhs, and also not to leave the country, leave the passport and other things with the police, and be available to the investigating agencies at the time of investigation. A conditional bail was granted as far as Sisodia was concerned under the PMLA Act. But the question is, that means that 1 lakh or 10 lakhs which he has deposited into the court by way of a fixed deposit, a charge is created over the 10 lakhs. That means that 10 lakhs, in case the accused absconds, accused runs away from the jurisdiction of the court, or the accused is not found, or the accused is absconding, then in that case, the 10 lakhs will be forfeited to the government. A charge is created over the 10 lakhs. That means the surety becomes responsible to produce the accused on every date of hearing before the court and not to violate the conditions of the bail order. And in case the accused absconds, then for all practical purposes, the surety has to attend the court on every date of hearing, and he has to produce the accused in court in body and flesh. Here, suppose let us say a wife who is not maintained by the family. Nowadays, you have most of the laws are tilted more towards the ladies because ladies are a special species now. They are being specially protected. You have got gender justice, that is domestic violence case, maintenance case, Hindu law of adoption and maintenance case, then family courts case. Even there, maintenance is granted because the woman has to maintain her body and soul together, and she shall not be left on the street to beg and maintain herself. Then that's the reason why maintenance has been provided. And here, this lady who has been deserted by her husband can ask for a charge over the property to the extent of the husband's share in the property, and then recover that money by way of selling that charge, enforcing that charge by getting that property sold, and then recover her maintenance from the court. That is what is called a charge created by operation of law. It is not by act of party. But the difference between a charge and a mortgage is a mortgage cannot be constructed by the court. The mortgage has to be interpreted as it is. But as far as charge is concerned, charge can be by act of parties or it can be by operation of law. That's a basic distinction between a charge and mortgage. That is what section 100 deals with. Then the other sections 101 and 102 and 103 you can please delete. Now this is as far as the law of mortgages are concerned. Next we pass on to the last topic in the Transfer of Property Act called law of sales. Law of sales. That is dealt with by section 54 to 57. Section 54 to section 57. Already you know the definition of the word sale when I dealt the Sale of Goods Act, where there is a transfer of property in goods from property in goods in respect of movable property from one person called the vendor to a person called the vendee for a consideration called the price. It is called a sale. And the person who sells the property or transfers the ownership is called the seller, or the person to whom the property is transferred is called the buyer or is called the purchaser. And what is transferred is property in goods. Property in goods means loosely you can call it as ownership, title in respect to the goods, or the ownership in respect to the goods. That's why in sale of goods you call it as property in goods. But as far as section 54 of the Transfer of Property Act is concerned, a sale is defined as where there's a transfer of ownership in respect of immovable property from a person called the seller to a person called the purchaser for a consideration called the price. It is called a sale. And the person who sells the property is called the seller, and the person to whom the property is sold is called the purchaser, or is called the seller is called the vendor, and the purchaser is called the vendee. And the consideration is title or rights, proprietary rights in respect of the property is transferred by the seller to the purchaser, and in exchange, the consideration on the part of the purchaser is he gets the ownership of the property and he pays the price as far as the acquiring that property is concerned. Then that is the consideration as far as the seller is concerned. Seller gets the price and purchaser gets the property. And what is transferred is ownership is transferred. Please remember, in immovable property or the Transfer of Property Act, we don't use the word property in goods. Property in goods is used only in respect of Sale of Goods Act. But as far as Transfer of Property Act is concerned, we use the word ownership. So then one thing is this. Once the property is transferred, what passes on? Here, normally when you draft a document, most of you are advocates. We know when we draft a document, we say there must be an offer, there must be an acceptance, there must be consideration, there must be a capacity, there must be free consent, and there must be legality of object as contained in section 6 of the Contracts Act. There must be an offer first, and there must be an acceptance. And an acceptance is an offer what a lighted match is to a train of gunpowder. That's a oft quoted quotation. That means once acceptance is done, you cannot take it back. So in the sale deed which you draft, how do you write, sir? You say, Mr. So and so, son of this deed of sale made at so and so on this the day of so and so by so Mr. A, son of so and so, age so and so, occupation so and so, resident of so and so, herein after called the vendor, which term shall include all his heirs, assigns, and legal representatives in favor of Mr. B, son of so and so, age so and so, occupation so and so, resident of so and so, herein after called the vendee, which term shall include all his heirs, assigns, and legal representatives. Next para is whereas the vendor has offered to sell the whereas the vendor is the owner and possessor of house number so and so, advisory so and so, in survey number so and so, situated at so and so, by virtue of having purchased the same from so and so to a registered sale deed bearing document number so and so, dated so and so. Then next para is whereas the vendor of the vendor was the owner and possessor of the schedule mentioned property by virtue of having purchased the same from so and so through a registered sale deed bearing document number so and so, dated so and so. Next para. Whereas the vendor has for his family necessities has offered to sell the property described in the schedule to the vendee absolutely for a total sale consideration of rupees so and so. Next para is whereas the vendee has accepted the offer of the vendor and agreed, please remember, underline this word agreed, and agreed to purchase the schedule mentioned property from the vendor for a total sale consideration of rupees so and so. Next para, whereas the vendee has this day paid the vendor a sum of rupees 10 lakhs towards advance and earnest money and agrees and undertakes to pay the balance of the sale consideration within 6 months from the date of this agreement. Then next para is whereas the vendor hereby agrees and admits that he has received a sum of rupees so and so towards advance and earnest money, and the balance of the sale consideration is agreed to be paid within 6 months from the date of the execution of this agreement. Now this sale deed witnesses as follows. Then here it is said, I'm talking about an agreement. Here the first clause is what is transferred in a sale is the dominant heritage, that is the proprietary rights, the titular rights, ownership rights are transferred along with the servient heritage. What do you mean by servient heritage? The rights which you acquire over your neighbor's property from country for being enjoyed for a period of 20 years, and then that right cannot be taken away, and those rights are also transferred to the purchaser. Then second one is advance, so it's free from all encumbrances. Then the vendor is competent to execute and register the document in respect of the schedule mentioned property, and then the question is that the vendor hereby agrees to get the land surveyed to the survey and settlements, and then demarcate and localize the land and deliver possession, or the vendor hereby agrees to deliver all the linked documents to the vendee at the time of execution and registration of the sale deed, and also in case the vendor refuses to register and execute and register the sale deed, the vendee is entitled to get the document duly registered through the process of the court. And in case the vendee does not pay the balance of the sale consideration, the advance and earnest money shall be refunded without any interest. Then normally in witness whereof the vendor has set his hand and affixed his signature voluntarily without any compulsion or force and in a sound disposing state of mind, then the vendor signs and the vendee also signs, and then the schedule of the property is also mentioned. What is the description of the property which is agreed to be sold or which is sold along with the boundaries. But the only distinction between a sale and an agreement of sale is an agreement of sale is an executory contract. Executory contract is some of the obligations are performed on a particular day and the rest of the obligations have to be performed later. It is called an agreement of sale. But sale deed is where it's a concluded contract, inter se, the vendor and the vendee, their respective obligations are already completed. There's nothing more to be done. And in agreement of sale, use the word agree. But In the case of sale deed, you use the word the vendor hereby sells, conveys, grants, and transfers all his right, title, and interest in respect of the schedule mentioned property to the vendee for a total sale consideration of rupees so and so, together with all easements and appurtenances. What do you mean by appurtenances? Appurtenances means the electric wires, the electric connections, the motor in respect of the property, the borewell, and also the tube lights or the fixtures which are there, fittings which are there, and the compound wall which is erected, everything pass on to the purchaser immediately on execution and registration of the sale deed. They are all called appurtenances. You don't mention in the document 40 windows, 40 doors, two borewells, two motors, electric wires, whatever is there, electric connection, so much and so. That is why it comes with a composite word called appurtenances. And one important thing you must remember is possession is of four types. One is possession is actual possession. Second one is physical possession. Third one is symbolic possession. Fourth one is constructive possession. What do you mean by actual possession? I hand over the possession of the property, vacant possession of the property to the purchaser along with the document. My job is over. Symbolic possession. I say, here is your plot, take possession of that plot. That is what is there. I show the plot, I show the boundaries, I localize the boundaries and give, and show symbolically deliver possession. Constructive possession means where there is no actual delivery of possession, but there are tenants in respect of the property. I attend the tenants and tell the tenants from tomorrow onwards you have to pay rents to the purchaser, Mr. B, and he shall be your new landlord. Then that is called constructive possession. Please bear it in mind. Don't avoid mentioning the word possession. Possession plays a very important part. In jurisprudence, it is said possession is 9 points of title, uh, except against the true owner. Then please remember the precautions which you have to take when you draft a sale deed or a sale transaction is the schedule of the property has to be clearly mentioned. If you don't mention the schedule correctly, tomorrow you land yourself into trouble or land yourself into litigation. So be very careful when you mention the schedule. Then also you must be very careful to know the actual name of the vendor, and if he's known by his surname, also his surname has to be preferably mentioned. And what all you have to submit regarding the sale deed is you must submit the Aadhaar card Xerox, then you must submit the PAN card Xerox, then you must submit your tax receipt which has been paid up to the date of registration, and all the connected documents will have to be enclosed along with the sale deed and along with what is called the annexures 1A and 1B, that is particulars of the property, so on and so forth. And please remember under Rule 932 of the registration rules, now it has been mandatory that the photo of the vendor, photo of the vendee, and the photos of the witnesses and their addresses have to be separately mentioned, and the signatures also will have to be taken. And please remember, when you draft a sale deed, the back portion, the reverse portion is not for you. The reverse portion is for the endorsement to be made by the sub-registrar at the time of registration. But the only place where I found that the document is written at the backside also is in Chennai. In Chennai, they write the document on the backside also, in the reverse, but that is prohibited as far as the registration rules are concerned. And the registrar will not register your document if it is typed on the backside. It should be typed on a single page. And backside is not for you. Backside or the reverse is meant for the endorsement to be made by the sub registrar at the time of registration. Here, I would like to dilate on one point called Faroktanama. In Urdu, they call it as Faroktanama, means that is where the document sale deed has already been done, nothing has to be done, possession has been delivered, registration has been done. It is called a Faroktanama or the sale deed. But here, one thing is remember is whenever you want to get an agreement enforced, you can only get it enforced regarding executory contract, but no suit lies for specific performance against executed contracts. This is a basic rule which you must remember. Nowadays, we are coming across hybrid documents called agreement of sale cum general power of attorney. It has been categorically held in one of the leading cases of the Supreme Court in 2015. That is the famous case of Suraj Labs Limited versus the state of Haryana, where they say that suppose an AGPA is drafted or executed and a suit is filed for specific performance, and unless and until the entire consideration is paid, entire stamp duty is paid, the specific performance cannot be granted. So this is as far as the sale is concerned. The rest of the provisions as far as sale is concerned, we shall discuss it tomorrow. Now the house is open for interaction, please. Oh, madam. Good
Good evening, everyone. Anurag, you have a lot of questions today, I hope so. About 10 questions are posted. Sir, Anurag has a lot of questions today. 10 questions.
Yes, madam. Anuradha Bakaraja.
I'm coming over there. Miss Prince.
Lot of questions today from Anurag Garu. Can you switch on your mic? 1 second. Hold on. Hold on. Madam. Yes, Anurag Garu. Please go ahead with your questions, madam. 10 questions are posted. I hope so. Yeah, Redmi 9. She's all right. I'll I'll clarify your questions, ma'am. One by one. Before I start, Anurag Garu questions. Please, anybody have any questions, other questions? Please let us know so we'll clear it up. Please go ahead, ma'am. Anybody else have any questions? I don't think so. Nobody has a questions except Anurag Garu. Today is all questions about Anurag Garu, madam. Ma'am, please come here.
As far as a rental agreement is concerned, it's a unilateral document executed by the tenant in favor of the landlord. But as far as a lease deed is concerned, lease deed is a bilateral document interse the lessor and the lessee. Some of the obligations are on the part of the lessor, that is the landlord, and some of the obligations are on the part of the lessee, that is the tenant. And both of them sign, and both of them are bound by the stipulations which are laid down in the lease deed. It's a bilateral document, but a rental agreement is only a unilateral document executed by the tenant in favor of the landlord. Is it clear to you, please? The first one.
Sir, in some states, instead of entering into a lease agreement, they execute lease and license agreement. Is there any difference also, or is it correct to enter a lease and license agreement or a license agreement when you are talking a bigger property on lease? Is that correct practice?
As far as license is concerned, it is granted only in respect of temporary account. For example, suppose a person is serving the mosque as the Pesh Imam, or as a person is serving the temple as the priest of the temple, the property is given to him not on lease, it is on license. So long as he is in service of the organization, he can remain in respect of that property. But there is no tenancy created in his favor. The tenancy is not there, it is only a license. Another instance can be given in the railway station. You find lot of kiosks vending eatables and coffee, tea, and all. They are all called licensees. They are not called tenants. They are not called deceased. It is there only for 1 year. It is given to them, and for that 1 year they must vend their goods. And after next year, a fresh tender is called for. And if these people can also participate in the tender, but they cannot get a right in permanency. That is what is called a license. License is a temporary. For example, suppose you are a government officer. Let us say an accommodation is given to you, and you pay the HRA or you pay the rent in respect of that lease rent to the government or to your employer. Then that is a license. So long as you are in service alone, you can remain in occupation of the quarters. But once you are transferred from this place to another, you cannot claim a right in permanency as far as that property is concerned. And a license is not heritable, please. That is the main important thing you must remember. Your children will not get rights over the license. But as far as lease is concerned, it is heritable. Your children, your progenies also get the rights to be in occupation. That's the different, basic difference between a license and a lease. License is your occupation is unlawful, but it's made lawful by giving you permission to stay in the premises by virtue of your services rendered to the organization. That is called a license
For a limited time.
for a limited duration of time, subject to the condition that you must hand over possession as and when called upon.
And extension and
Unless it is extended. But here you must remember there is an act called Public Premises Unauthorized Occupants Act. Suppose you are transferred from Hyderabad to Warangal, you can remain in possession for 3 months. Or suppose you, as condition, you can say, my children are studying, I cannot disturb their education. You are given a further period of 3 months. After that, you stay, you become liable to pay what is called penal charges, 1.5 times or 10 times the amount what you pay as rent. So license does not create permanent occupancy. It's not heritable, and whenever possession is demanded, you have to hand over possession fees. That is the essence of license. But as far as lease is concerned, it is given for a fixed duration of time, and you can occupy the property so long as it is mentioned. And your children also get rights. Suppose by chance you are not alive, your children also can continue in respect of that property. That is called a lease. A lease creates a right in permanency, but as far as license is concerned, it's only for a temporal period. And once the purpose is accomplished, you will have to deliver.
that will be an idea in a contract basis.
Normally, it's a contract.
And the tender calling.
Next question. Sir, in the definition of lease in TP Act, it is said the price is called the premium and the money, share, service, or other things to be so rendered is called the rent. So, what is premium and what is rent as per this definition in TP Act?
As far as the definition of the TP Act is concerned, rent is the amount which you agree to pay in respect of being an occupation of the property. But as far as premium is concerned, when you are inducted into possession of the property, you pay 6 months rent or 8 months rent as advance, and that is called the premium. And that is refundable.
What is actionable claim?
Actionable
This term
claim.
is used in TP Act.
As far as actionable claim is concerned, a particular document which gives rise to an action in a court of law is called an actionable claim. For example, a promissory note, a check, or a bill of exchange, based on which you can initiate legal action against the opposite party, is called an actionable claim.
So, what is the difference between administrator, executor,
That's it.
and permitted assignee?
As far as executor is concerned, he is a person who implements the will, implements the desire of the testator or the testatrix. As far as the administrator is concerned, who manages the property, looks after the property, collects the rents in respect of the property, or in other words, he takes care of the property, is called an administrator. The other person,
Assignee, permitted assignee.
permitted assignee, is where the property is assigned to a particular person, transferred to a particular person, permitted to a particular assignee, and that person has to do what the assigner would have done. That is called a permitted assign.
Right? Sir, in copyright or in trademark, when all rights are transferred on person to another, why is it usually referred to as assignment of copyright or trademark? Why is it not called sale of copyright or trademark?
There cannot be a sale of trademark or sale of what is called copyrights. It can only be transferred by assignment. The Copyrights Act as well as the Trademarks Right prohibits sale, prohibits mortgage, etc. Only assignment can be done, but notice of assignment has to be given by way of publication.
But again, it is a copyright. It has to be given in a proper way, saying that those are certain measurements
And
in the
the
copyright.
and the registrar also will have to be
Will have to be registered, informed, and
because
properly.
they are all called intellectual property rights.
Absolutely. If now in the banks, logos, everything is designed by themselves, and even it is been designed in such a with measurements, you have to file it for the copyrights. And
it has-
patent rights
and
also
it has
will
to
be
be
there.
registered before the registrar of copyrights and patents.
Yeah, absolutely. And then only if any entity that is the
Then
company is
only
getting
it becomes-
sold off,
then only it becomes enforced, not
yes.
otherwise.
If a company is getting any sold off with the property and with the logos it is sold, then it comes to us.
That arises mostly in the case of amalgamation of companies.
Absolutely.
What is the meaning of assigns that we see in recital?
Assigns means a right which is transferred to a particular person is called assignment, and such a person is called the assignee, and the person who transfers the right is called the assigner, and the transaction is called an assignment.
What is the difference between occupancy certificate and possession certificate?
As far as occupancy certificate is concerned, when the suppose
Building
you
is
are talking
completed.
from agricultural lands or from buildings, please. If it is regarding buildings, if it's regarding agricultural land, suppose it's an Inam land, the proper all properties after 1/1/1973 vested with the government. And before that, if you are the Inamdar, an Inamdar Inam is a person to whom a Jagir is given or to whom a Inam is given. That person can transfer the property. Suppose he has got what is called ORC. ORC means residential certificate. Occupancy certificate means suppose a flat is ready and the flat is going to be given to you, then the question of the builder has to give you the right of saying you can
Occupation
occupy the
certificate.
property, take possession of the property.
Take
That's
possession of the
called
property and it is complete and hand over to the particular person who
Person.
is sold.
that's all.
Sir, in a sale deed, if the parties agree that payment will be made after 1 month, is it executory or executed agreement? Is the sale absolute in this case, though money is to be paid later?
It is a conditional sale rather the entire amount, the question of installment that till such time the balance is paid, the seller will have a charge over the property. That is which for the unpaid
Sir,
money which has
Sir,
been paid.
is that registered? Is that registered, madam?
Sale deed is registered.
If sale deed registered, again a conditional sale deed will be done again. Registered.
So it applies only in the case of where the clause is included in the
And
sale.
a sale deed.
But normally nowadays suits
Yes.
are being filed saying that though the consideration is mentioned, I have not received any money. That's absolutely false. No person will execute a document without taking the money.
Without taking full amount, the charges will not, I mean, when a sale deed is absolutely done, especially full payment is done, then only sale deed will be executed.
But if it is conditional that after
Again-
1 month it will be paid, there will be a charge over the property for the unpaid purchase money.
Again, if, as sir says, if there is any conditional sale, again the clause is included in particular sale deed and the period, what time that the payments will be done. Otherwise, the sale get cancelled again.
It is partly executed and partly executed.
That is a little bit hybrid for document what you are saying, which is never been done by the realtors. Absolutely, the realtors will not do it. Only the complete payment, then only the occupation certificate and other amenities, car parking, these kind of things will come and again for your betterments. I hope so. This is a hybrid document. What you're talking, I don't know where you got this hybrid document.
Next, what is A khata and B khata, and also what is E khata?
A kata, B kata, E kata.
AATHA.
A kata.
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 Account.
Kata means account. Account.
A
And that
khata
is
and B khata. Also, what
there's
is
no
E
question of
khata?
A kata, B kata, and C kata. There's only one kata that's called in
Accounts
Marwari language as Paddu.
But
That is
accounts.
the account book.
What is she saying?
There's no A kata, B kata, C kata. Or na kata.
But in Bombay, they entered leave and license agreement.
Leave and license is permissive occupation.
I'm
That is, you are given a right to occupy a property for a duration of time. Once the period comes to an end, mere asking for delivery of possession is sufficient. That is called leave and license.
as you say,
Permissive occupation.
as you say in Bombay, there are called as pagdi. And they take heavy pagdis, especially in North culture, and they take minimum 1 year of pagdi or 6 months pagdi minimum. Then only you will get a sale deed or lease agreement will be done between the tenant and the owner.
I'll give you one example of Karnataka, please. Here in Karnataka, what they do is they collect 3 years rent at one time or 5 years rent at one time. And the person who lets out that house is a businessman. The 5 years rent is used for rotating it in the business. And once that 5 years, you need not pay the rent for that 5 years. That amount what you pay towards the heavy amount of 5 years rent is appropriated by the landlord towards the rent. and then after 5 years, suppose you want back that amount, or let us say some amount is outstanding, or you want a renewal, then he says, "Come on, give me another 5 years rent." That is at the most it's a loose usufructual mortgage.
Again, it's hybrid document. What is this?
This is prevalent in Karnataka, please.
And Mr. Nag.
And in one minute, in Karnataka, there's one more restriction also imposed. That is, they have A schedule and B schedule. Suppose, let us say, the color of the wash basin is white, then color of the tube light is white, then the color of the switches is white, then color of the fans is white, the color of the toilet seats are white, then color of the building, the color of the flats, color of the rooms is suppose let us say cream. When you hand over possession, you have to restore it back in the same position when it was given. This is what they follow in Karnataka, please. Please remember, lot of restrictions, but unfortunately, our Telangana and Andhra, we are very, very magnanimous and very, very benevolent. We are very, very sympathetic towards tenants. That's why we get into trouble with tenants also.
Mr. Natraj, is there any fixed rules regarding taking of a stamp paper, that is in whose name to be taken, regarding the rental agreement, sale deed and other documents?
Normally, the rental
సింపుల్ నటరాజు గారు, మీరు రెంటల్ ఇవ్వాలనుకుంటే ఎవరి పేరు మీద తీసుకోవచ్చు. దట్ ఈస్ డిపెండ్స్ అపాన్ ద కంఫర్ట్ జోన్స్ యు ఆర్ బీన్ గివెన్ by your tenant, I mean by your owner or yourself. I mean, it is sale deed, it is better that you take it on the owner's name. But other documents, rental deeds again depends. And other documents I don't know what are the other documents.
But now stamp paper also is not required. You can type it on a ledger paper. On the reverse, they collect the stamp duty and they collect the receipt. But to look better, you take 100 rupees stamp paper and get it
better that you take a stamp paper. Okay, Vivo. If there is a difference between schedule of the sale agreement and actual title deed, what is the remedy for the plaintiff object vendee?
The vendee has to file a suit for rectification under section 26 of the specifically fact, get it rectified. But normally, agreement of sale, you need not bother about it because agreement gets wiped out once the sale deed is made. So it gets merged with the sale deed.
Again, becoming Anurag garu. But how can a big property in Bombay gives under lease and license through for a real reasons? It is lease. Is it fair, ma'am? As you say, the practice of Hyderabad, the practice of Vijayawada, the practice of Vizag, the practice of again Karimnagar have a lot of differences.
We are more benevolent than magnanimous. In Bombay, to get a rental accommodation is a tough job. It's something like acquiring a bride.
Ma'am, it differs court to court. It is getting differences. I don't know on how way it is in Karnataka.
In Pune, it's still worse.
That is different scenario again. Mr. MVS Sharma, A Khata and B Khata exist in Karnataka, sir. Karnataka. I think A Khata has approval from the government of B Khata, and B Khata ownership exists. No allowed approvals. Banks will be not sanctioned. I think Sharma garu is right because Karnataka government is only dealing with.
In Telangana, we got deep patta. That is assigned land. Deep patta is assigned land.
Very well clarified. Lot of source.
And we have also Lavanya patta or what is called Levani patta.
Even Chuttal patta.
Our Ramoji film city is nothing but Levani patta only.
All right, thank you very much. And any more questions? Please go ahead.
Yes, sir. Can I ask?
Please go ahead, sir.
Nowadays, this Franklin machine stamping is there, no, sir?
Yes.
But generally,
Okay,
I don't encourage.
No, sir.
The sale dates and agreement of sales because better you take a stamp.
No, one thing, sir, regarding if a person has written on the plain paper and later it was franked by the other party.
That is valid, sir.
Sir, by the other party, again I'm telling you, that will be a fraudulent document in the future.
First, just on the white paper, he has taken
No,
the
that
signature.
is what I'm saying. Again, that will be a fraudulent document in the future, I said. Because
So what
if a stamp paper is taking in these days, an Aadhaar card and time of date which name, how it is taken, phone number, everything's mentioned.
They have the register also.
They have the register through what time it has been taken, and it is printed on a particular stamp paper.
And there's an accession number also.
So if it is going to franking, again, they take your number and phone and other date. It is not registered on online.
Date can be manipulated.
The person who is signing the document, who is signing the white paper, he assumed it is a white paper, no? So if
That is what I'm saying. That is what it's a white paper. They assume it. Later on, it is getting franked.
Yes, yes. Then it is enforceable.
It is enforceable, but that is what I'm saying. Better you take a stamp paper.
Sir, in this regard, I try to refer to our Telangana Revenue ROR Act. They call Sada Bainama. Sada Bainama is what you're referring to is a plain white paper on which the document is written. But the revenue authorities have got the power to collect the stamp duty, paying it to the treasury, and they endorse it saying that the stamp duty has been collected, they validate the document. That is called Sada Bainama under Section 5A of the old Act. That is the ROR Act. Now, new Act also has come as far as ROR is concerned. They have now dispensed with Dharani. Now it's called Matrubhumi.
Again, any more questions before I go to another question? All right. I'm going to the next question, sir. Mr. Sriram Chandra. Sir, difference between pattas D and B.
Pattas?
D patta and B patta.
As far as D patta is concerned, it is allotted by the government 60 square yards or 80 square yards to the landless poor. And assignment is done regarding that 60 yards or 80 yards maximum. But as far as B patta is concerned, it is given to people from the army and air force and navy. That is in recognition of their services. Agricultural land or land is given whereby they can use that property, and it is not alienable for a period of 10 years except with the permission of the collector after the expiry of 10 years.
Right. Any more questions? Can we conclude the class for today? All right. Thank you very much. We'll see you soon.
Thank you, sir.
Thank you.
Madam, there are only 3 sections.